This meeting of the Senate Judiciary Committee will come to order. Well, it was a long time ago, many years. I was a young lawyer on my first assignment. New graduate of Georgetown Law School, I returned home to my home state of Illinois, where I was working in the Illinois State Senate for the Lieutenant Governor, Paul Simon. At the time, the lawmakers in my state were considering the ratification of a constitutional amendment that was first introduced many years before in 1923. It was called the Equal Rights Amendment. Well, here we are, a century after its first introduction, 2023, and here I am, nearly 50 years after I started that first assignment. It's time to get the job done. In fact, it's long overdue. Today, this committee is holding a hearing on finally enshrining the Equal Rights Amendment into the Constitution. I want to start with a video. Thank you. I want to start with a video which gives us a little insight into the history of this issue.
It was almost 100 years ago in 1923 that Alice Paul, a leader of the women's suffrage movement, first introduced to the public an idea of what would eventually become the proposed Equal Rights Amendment.
The debate is as old as the country itself, and the premise hasn't changed much since suffragette Alice Paul first wrote, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex."
Gradually, instead of a little tiny cluster, we now have 10 million women backing this particular measure before Congress.
It took 50 years for Congress, mostly made up of male lawmakers, to take action, passing the amendment in extraordinarily bipartisan fashion. But it faltered in the states.
The ERA ran out of steam and hit a wall. Now, there's new energy to try one more time to get it ratified.
There is no deadline on equality.
It's clear that the need for the ERA is just as fiercely urgent today as it was a century ago.
We know that the three states that made the most recent difference were Nevada, 2017, Illinois, ratifying the ERA just a year later, and 2 years after that, Virginia became the 38th state, pushing the ERA past the threshold.
It is possible to create gender equality in this country.
And a final recognition that women and men are equal.
Said you cannot put a time limit on women's equality. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex.
I apologize for the audio. We'll try to make that a little better last time, but we didn't want anyone to miss any words. The principle of equal justice under the law is fundamental to who we are as a nation. But unless that principle is protected in our Constitution, it is nothing more than words. For 100 years, Americans have been fighting to enshrine equality in our Constitution with the Equal Rights Amendment. 100 years. In the half century since Congress approved the ERA, 38 states have ratified it. That's the exact number of states needed to certify the ERA as the 28th Amendment to the Constitution. So why the holdup? When Congress first approved the ERA in 1972, it imposed an arbitrary time limit on the ratification process. But that was more than 50 years ago. In the decades since, as I mentioned, the amendment has crossed the 38-state threshold, with Virginia becoming the most recent state to approve it in 2020. Think of it this way. If not for Congress standing in the way, the ERA would already be on the books. So it's time to clear the path for equality. The joint resolution we're considering today will repeal that arbitrary deadline in the preamble of this resolution once and for all. There is no room for uncertainty when it comes to protecting equal rights under the law. Sadly, that lesson was driven home last year by the Supreme Court's decision to overturn Roe versus Wade, and for the first time in history, to take away a constitutional right from every woman in America. For years, we've heard well-known arguments against the ERA. I remember the single-sex bathroom argument of many years ago. Some have argued that it's not necessary. Others have argued it's dangerous. Others have claimed that the ERA and the 14th Amendment are redundant. The reality is that the Supreme Court, which at the time was made up entirely of male justices, established a lower level of scrutiny for sex discrimination claims under the 14th Amendment. The ERA would finally change this. When we have a conservative supermajority on the Supreme Court who believe the meaning of the 14th Amendment was set in stone when it was ratified in 1868, the ERA is far from redundant. When a sitting justice on the Supreme Court, Clarence Thomas, argues that the court should reconsider constitutional protections for family planning and birth control, protections the court recognized under the 14th Amendment nearly 60 years ago, the ERA is far from redundant, far from unnecessary. So now the question for members of this committee is straightforward. What kind of America do we want to leave our daughters and granddaughters? A country in which their fundamental rights are safe and secure, or one in which the Constitution continues to fail to recognize fundamental equality on the basis of sex? As a father and a grandfather, I think the answer is obvious. Let's live up to the promise of equal justice under the law. Join us in supporting this resolution to revoke the deadline on the ERA's ratification. There is no time limit on equality. With that, I'll turn to the ranking member, Lindsey Graham, for his opening statement.